SJC-11589, Commonwealth v. Thomas E. Toolan III.
Attorney Mencken.
Good morning. I'm Michelle Mencken on behalf of Appellant Tom Toolan III. May it please the court. This morning, I intend to address the first three arguments in appellate's brief in order. So the first issue in the brief concerns the testimony of the Commonwealth's expert, Martin Kelly, which was wrong. The testimony that the terms mental disease or defect are written into a statute that determines criminal responsibility in Massachusetts at a time when those terms had a specific meaning in psychiatry was wrong. There is no criminal responsibility statute, and contrary to the clear implication of Dr. Kelly's phrasing, the legal definition of mental disease or defect is not a matter of medical or psychiatric terminology. Even if he were correct, it's not his place to be opining on the statute that would usurp the judge's role and intrude on the jury's function to apply the facts as given to them by the judge. I'm sorry, the law as given to them by the judge to the facts. So when defense counsel objected to this testimony, three things should have happened. The testimony should have been stricken. The judge should have immediately interjected an instruction to the jury that the law comes from the judge, not from the witness. And it would have been appropriate to do as defense counsel requested and instruct the jury in the closing charge supplemented the comments on mental disease or defect to clarify the distinction between the psychiatric expert's medical understanding of the term and the jury's prerogative to find a mental disease or defect independent of that.
So counsel, do you think that there's anywhere in the testimony of the ME that or the doctor that was correct in terms of how he or she characterized that phrase?
I don't doubt his own understanding of the term as a doctor. So he had his own definition that applies to him as he's making certain assessments. But I don't, as far as the law stands right now, I don't think that his testimony in any respect was in line with the legal definition, because there essentially is no legal definition other than the jury is allowed to look at all of the evidence of mental impairment and make an assessment about whether that constitutes mental disease or defect.
You want to address whether it's a substantial likelihood of a miscarriage of justice, though? Sure.
So it is in this case, because whether or not Mr. Toolan had a mental disease or defect that would sort of qualify, that was legally cognizable and would give rise to the further considerations in the criminal responsibility test, the jury would have to find that he had this qualifying mental disease or defect. So no other expert for the defense sort of took it upon themselves to say what was or wasn't a mental disease or defect. They testified to their observations, they testified to their conclusions as to what was going on in his brain, but they didn't say this is or isn't a mental disease or defect because of XYZ. They just said he's got the frontal lobe damage, he's got disorders of memory, perception, thought, and mood. And by the way, I just want to correct my sister's brief mentioned that the defense expert said that there were just mild disorders of memory, perception, thought, and mood, when in fact what was said was that there was frontal lobe damage, and to a milder extent there was also disorders of memory, perception, thought, and mood. So these were real things, not just mild. He had substance use disorder. He was acting psychotically. So according to the law, according to Mullica most clearly, the jury could look at all of this evidence and make its own determination as to whether there was disqualified for their, real, genuine consideration of whether he lacked substantial capacity to conform his conduct to the requirements of the law. And to be clear, that was the only prong that his defense arose under. But under Dr. Kelly's definition, which was echoed by the judge's instructions, the exception possibly of frontal lobe damage would qualify. And he his definition would encourage the jury to look at these diagnostic labels, and they did not need to be tied to any of these diagnostic labels.
I'm confused. I thought the judge gave the model instructions.
He
So
did.
he gave the model instructions, and how does he then include erroneous statements of law from Kelly? I'm confused how that happens.
Sure. So yes, he gave the model instructions, but the instructions don't define mental disease or defect. And I'm not arguing that the instructions always have to. That is a claim that has been asserted in many cases before. And there is a suggestion in the law that it would aid the administration of justice. But I am arguing that without that definition here, where Dr. Kelly has given this other definition, that's where the jury could be confused. If Dr. Kelly had given this erroneous legal definition, and then the judge had correctly instructed on the legal definition, then maybe the harm would have been mitigated, as happened in, I believe, Piantadosi is a good example of that, and Berry is another example of that, both cited in my brief. And how did the judge's instruction kind of echo Merton Kelly's testimony? That was because in particular, what the judge himself noted was that there was this reference to antisocial conduct disorder not being included. So the only thing that the model jury instruction says about mental disease or defect is that it's not antisocial conduct disorder and it's not intoxication. And it's a legal term and not a medical term. So what the judge was saying to defense counsel is like, I'm not going to add anything. I'm not going to make this any clearer to the jury than what Dr. Kelly has done. And I'm going to be echoing him and bolstering his testimony, because Dr. Kelly said that personality disorders, and in particular antisocial personality disorder, won't cut it. And that's what the model instruction says too. So the impression that the jury is going to get is that Kelly is correct, that he is in fact reciting a real definition, which he was not. And so the danger and the substantial risk of a miscarriage of justice is that the jury is not going to understand that it actually was entitled to look at these more minor disorders of memory, the inefficient thought processes.
Counsel, if I could ask you though, as to the substantial likelihood of miscarriage of justice issue, what Dr. Kelly did was clearly give his understanding in psychiatry of the term mental disease or defect. What the judge told the jury clearly, following the model instructions, is that mental disease or defect is a legal term. So from that dichotomy, how do you get to a substantial likelihood of miscarriage of justice?
Because when the first part of what you said was that Dr. Kelly clearly said that this was his sort of psychiatric understanding, and I disagree with that. And I disagree with that because he actually said there's a statute and this is what the terms mean in the statute. And then when defense counsel objected, he said, okay, well, here's what it means in psychiatry. And he used the exact same language. And so without any correction, without telling the jury, here's why defense counsel objected, here's what's wrong about what Kelly said, how is the jury supposed to know that this is limited to just the medical psychiatric?
Well, because the judge judge said that you follow the law provided by the court. And the law provided by the court was that mental disease or defect is a legal definition.
That's so two things. One, actually, if you look at the final charge, I actually looked for a place where the judge would say, you know, I give you the law, follow the law that I give you, and I didn't find it. But also, Kelly gave a legal definition. So if the judge says, this is a legal term, not a psychiatric term, and he doesn't tell the jury what the meaning of the legal term is, but Dr. Kelly said, it's a legal term, it's defined in a statute, and here's what it means. And they're never told that that's not right. So that's how you get to a substantial risk of a miscarriage of justice, because this is a critical factor for the main defense, and the jury was misled. And our position with respect to that, if there are no further questions, I'll move on to the second issue. And just so the second issue has to do with the distinction between the lack of criminal responsibility instructions and the diminished capacity instructions. And our position is that, and there are really two aspects to this argument here. And there's a little bit of overlap with the issue that we just discussed. So the first issue is that the distinction was not clearly set out in the jury instructions. And the second aspect is that the distinction between mental disease or defect as required for criminal responsibility defense and mental impairment as required for a diminished capacity defense also was not clearly explained to the jury. So to the extent that the jury was misled as to that there was a very high bar for mental disease or defect and didn't understand the breadth of sort of factors that it could take into consideration.
Well, counsel, can I ask you a question? What effect would the defense have had on this in terms of the defense expert witnesses and how they testified about that issue?
Well, what's remarkable about the defense witness testimony is how very significant Mr. Toolan's intoxication was to his behavior. He had copious amounts of alcohol and sort of an unreal amount of pills. So he was certainly, his behavior was affected. There was strong evidence that his behavior in this case was affected by that consumption.
Mm-hmm.
So
well, did the expert, the defense expert, define mental disease or defect?
No, they never did. They never did. And I think that the testimony was simply, what was going on in his head, and the expert said, here's what's going on in his head, and the terminology was not used in the way that it was in the examination.
But he did do, I thought, well, I think it didn't the witness, Dr. Joseph, testify that disease or defect was the number of processes occurring at the time that rendered him unable to conform his behavior to the law?
Correct.
So he did give a definition.
Well, I would disagree that he gave a definition. I think that what defense counsel asked him, and you correct me if I'm wrong, but my recollection is the defense counsel asked him, do you think that Mr. Toolan had a mental disease or defect, and what was going on with Mr. Toolan? And he said, here are the number of processes that were happening in Mr. Toolan's brain. And the distinction between the way that he talked about it and the way that Dr. Kelly talked about it is Dr. Kelly sort of said, here's what is a mental disease or defect. It's a disease, first of all, which means that it has a biological component and it responds to medication, and the person doesn't necessarily know that they have it or have any control over whether they do or don't have it. And I won't go on and on about it, but he gave a sort of a definition that could apply to any scenario, whereas Dr. Joseph said, here are the processes that I consider to be a defect in Toolan's mind. And the question is, would the jury think that any of that was legit, that was entitled to their consideration based on the definition that had been given to them by...
Counsel, can I ask you on this particular issue, What's the standard of review on this issue? Because wasn't there a request for clarification and didn't the judge deny that?
Yes, on the second issue in the brief, that the Commonwealth agrees that that is a preserved error.
So is the standard prejudicial error on this issue?
Yes,
Okay.
that's my understanding.
So
Yes.
from that framework, wasn't there a lot of evidence here that, I mean, you have a lot of evidence here that the jury was given as to what Mr. Toolan's actions were the day before and the day of and directly precede this. So do we have prejudicial error here in light of all of the evidence that came in about what Mr. Toolan did in the days and the hours before this murder?
Well, I would say yes, because part of what he did in the days before was get sort of out of control, intoxicated, and exhibit his impairment, his suicidality, and all of these things that could have been considered by the jury in a sort of diminished capacity context. This could have led to a second-degree murder conviction, and we've seen it in other cases. So I would say yes. If you're asking about the Commonwealth's position that Mr. Toolan's conduct in the days leading up to the offense showed executive functioning, planning, step after step, and things like this, I mean, it's a jury question. It's a jury question whether those things, establish that he had full enough cognitive functioning to be able to contemplate, to premeditate, form a specific intent to kill. There was testimony from Dr. Joseph specifically on this point, and that's the defense expert on criminal responsibility, specifically saying that it wasn't necessarily so that Mr. Toolan had a specific intent to kill, that he had taken these steps with the intent to harm her, because that's how irrationally he was behaving and thinking and psychotically.
Well, I know that you're saying that counsel should have been, that the requested additional clarification, but I got to go back one domino. Are you saying that the instructions that the judge did give did not comport to what was required to be given at the time?
The judge gave the model jury instructions on homicide, and our position is that in a case such as this, they needed to be supplemented as counsel requested, and in fact, as the judge himself flagged.
Thank you.
Thank you. If I'll just briefly touch on the third issue in the brief, which, and I'm touching on it because at first blush, you could respond as the Commonwealth did to thinking this is absurd. We're asking that addiction excuse all conduct that is undertaken while the person is intoxicated. And that is not actually what this is about. This is about a really clear dissonance in the law. This exception to the De Padova defense or charge, or the De Padova charge saying you may lack criminal responsibility if you have a mental disease or defect that was triggered by alcohol. So once upon a time, back in Sheehan days, if you became voluntarily intoxicated, that meant that you were fully responsible for everything that happened after. And at some point, this court said, we want to clarify that just because you became voluntarily intoxicated, if that triggered a mental disease or defect, you're still lack criminal responsibility. But then there's this exception. You're still fully on the hook if you knew that that becoming intoxicated would cause you to act violently or would trigger your mental disease or defect. But interestingly, since Sheehan, the court has said, well, never mind Sheehan's thought that you can't consider intoxication on specific intent, for example, you can, because it's totally unjust to have somebody be found fully culpable for their conduct if they in fact were so obliterated that they didn't know what they were doing. And that is true whether or not the person who is using the alcohol knows that using alcohol is going to cause them to get drunk and to make poor decisions and to not be fully functioning. It doesn't matter. And this is the only context in this type of scenario where it matters, where you are sort of strictly liable for the consequences because you knew. And the question that I have for this court is why?
What you say the Commonwealth is overstating this or misinterpreting what you're saying. What is the limiting principle for what you're arguing? How will this not be a get out of jail free card? Explain that to us.
So in the short time that I have, the answer is because in this unique context, liability is flowing from the choice to use substances, not from what you do once you're intoxicated. So this is a person who is not criminally responsible. They meet both prongs of the McCool test. Or I'm sorry, they need at least one prong. They satisfy the McCool test, they would be found not criminally responsible. But they are still on the hook because they made this choice to get drunk. And our position is that when liability is flowing from that and not from the conduct itself, that it just, for example, same with the probation violation. Or I've given you a few other examples in the brief about sort of loss of veterans benefits. But when the question, when liability is flowing from your decision to use, it is only fair to allow the fact finder to consider whether that was a willful choice. And there's no other circumstance. This is not, in any other circumstance where somebody is saying, first of all, intoxication is mitigating in every other circumstance at this point in this day and age. But so the example I gave in my brief is somebody who says, well, I robbed the bank. This wasn't my brief, but here's an example. I robbed a bank because I needed the money to feed my cocaine habit because I am addicted. So addiction is not an excuse there, because what you have done is the law has said that being intoxicated and addiction is not a mental disease and defect that you can claim I had a lack of criminal responsibility for that behavior. So the only issue is whether the addiction doesn't excuse it. You're on the hook because you robbed a bank and you are criminally responsible. In my situation, the person is not criminally responsible, but they are being held criminally responsible because they should have known that this would happen. Whereas when alcohol is considered as mitigating knowledge, intent, deliberate premeditation, that does not turn on whether the person knew that getting drunk would cause them to make these poor decisions. Or, I don't know if I've made that answer clear enough, but I know I'm over my time.
Okay, thank you. Attorney Sweeney.
Good afternoon. May it please the court, Elizabeth Sweeney on behalf of the Commonwealth. Addressing the first argument, Dr. Kelly's brief comment regarding his understanding of the term mental disease or defect as a psychiatrist, referring briefly to a criminal responsibility statute and not opining on where that statute's from, does not result in a substantial likelihood of a miscarriage of justice. Dr. Kelly's brief comment, which was objected to, and then the Judge Nickerson redirected the witness and the prosecutor asked a different question, did not blur the distinction between criminal and legal concepts. And in this case, the jury was properly instructed under the model jury instructions. Defense counsel stated that he was happy with the model charge on volume 7, page 1295. And the jury heard that the phrase mental disease or defect is it is a legal term. It is not a medical term, and it does not need to fit in a formal medical diagnosis. And the phrase mental disease or defect does not include an abnormality manifested by repeated criminal or antisocial conduct. And then the judge said, consistent with the model charge, that it's for the jury to determine, in light of all the evidence, whether the defendant had a mental disease or defect. So based on those jury instructions, consistent with the model charge, defense counsel's trial counsel's statement that he was happy with the model charge, and the fact that this issue was addressed on the record, I state that there is no substantial likelihood of miscarriage of justice. The jury was well well instructed. They heard from 4 different experts on mental disease or defect, alcoholism, substance abuse, frontal lobe damage, and also Dr. Joseph, the defendant's expert, did state that in his opinion, the defendant suffered from a mental disease or defect and gave reasons as to why he supported that statement. So in light of the litany of evidence on this subject and the very brief comment by Dr. Kelly, and the fact that Judge Nickerson immediately addressed it and directed the prosecutor to ask a separate question, I state that there is no substantial likelihood of a miscarriage of justice. Addressing the second issue about the difference between criminal responsibility and diminished capacity, I also state that the judge instructed the jury consistent with the 2013 model jury instructions. The jury was instructed by Judge Nickerson more than once on criminal responsibility, and the claim that the jury should have heard the differences is not appropriate. The judge should not be explaining degrees of intoxication or opining on separate mental illnesses that the defendant asserts that he has, because then the judge is sort of giving the jury, telling them how to weigh evidence on criminal responsibility. And this court has recognized in Commonwealth v. Fuller or in Commonwealth v. Torres that the subject of mental disease or defect is so complex and obscure that any general explanatory formula is likely to mislead and confuse. So here, the very issue at trial was criminal responsibility and diminished capacity, and the jury heard from many experts on that. And also the judge gave the necessary instructions in the adequate and the appropriate words. The judge first instructed on criminal responsibility, which this court recognized in Commonwealth v. Loya. And then as he got into the elements of the offenses and intent, he then said, and don't forget about criminal responsibility. He also said at the beginning, when he was instructing on criminal responsibility, that this is, the Commonwealth has to prove this, and this should be ever present. And I would be hard pressed to think of a more stronger instruction than a judge saying that criminal responsibility must be ever present in your deliberations. And the judge should not be required to explain the differences between the complete defense of criminal responsibility and then so-called diminished capacity defense.
When the judge does segue from criminal responsibility to diminished capacity, how does the jury know we're dealing with a different?
I'm sorry, I couldn't hear you.
So when the judge segues, so we're moving from criminal responsibility to the diminished capacity. So how does the jury know it's a related but a different concept? How does the jury understand that?
So the judge explains diminished capacity and how that relates to intent. And then he said, and also don't forget that the Commonwealth needs to prove beyond reasonable doubt that the defendant was criminally responsible at the time. So I think that in the Commonwealth's position, the jury heard the diminished capacity defense and how that relates to intent. And then he redirects them to the element that we have to prove, criminal responsibility, which they heard at the get-go. They heard right at the beginning of the instructions, which is consistent with the 2013 and also the 2018 model jury instructions. So they heard that that was ever present. And so I suggest that when he said that it was an element the Commonwealth needed to prove, that was the difference. And the difference is elusive and undefined, and rightly so. And I think just directing them back that the Commonwealth needed to prove that element is enough of a difference, and opining on it.
And what was the supplemental instruction that defense requested to clarify that? I can't remind me what it was and why it's not necessary.
The defense didn't say specific differences or degrees of mental illness or where intoxication should be explained. Judge Nickerson said, counsel, do you believe that the difference between criminal responsibility and diminished capacity is addressed? And he did object, but there wasn't any examples or frontal lobe damage needs to be listed under this category, or the fact that we allege that he took pills that morning needs to be alleged, here. So
the defense counsel requested some language from a different case, right? I can't remember what the defense counsel requested now. And the judge said, I'm not giving that, right?
Yes.
And What was that language and put it in context?
The specific case is not coming to my mind right now, but I do recall that the language was, I think it was Commonwealth v. Barry, but I'm not positive, and discussing examples and reminding the jury about weighing the evidence of intoxication and alcoholism. And the judge didn't want to get into this province of the jury and explaining to them how to weigh evidence and how to, how this is left for the jury. And he explained again that criminal responsibility is a matter that the Commonwealth has to prove beyond a reasonable doubt. So it's Commonwealth's position that sticking to the model jury instructions and not opining in additional evidence when that was the main issue at trial, thoroughly vetted the issue for the jury after all these experts.
He did stick to the model jury instructions, but at a point of transition, I think you, as you've already mentioned, he did more than that. When he was talking about diminished capacity as it relates to capacity to formulate intent, he also paused for a minute to emphasize that other issue we had talked about, criminal responsibility being ever present. So to the extent that there was a deviation from the model instructions, it was a deviation that helped the organization of the instruction precisely to the issue that the defendant was concerned about.
Yes, that's exactly the Commonwealth's position. And I describe it in my brief as he wove in the criminal responsibility instruction. He mentioned it no less than 6 times. He reminded the jury at every opportunity when they're dealing with intent that do not forget criminal responsibility. And he redirected them back to the initial instruction that he gave. And the model jury instructions for both 2013 and 2018 do state that if the main issue in the trial is criminal responsibility, that instruction should be given first. And it was given first here. And then he ended up discussing the elements of the offenses. And every time he discussed intent, diminished capacity, he again redirected them back to criminal responsibility. So that issue was at the forefront of the jurors' minds after hearing those strong instructions and also the 4 experts that testified at this trial. Addressing briefly the defendant's claim that the jury should have heard whether addiction rendered the defendant incapable of resisting the urge to use substances. I just note that in 2011, this court issued the opinion in Toolan and stated that the judge should consider Commonwealth v. Padova, and now the defendant challenges that that instruction was given. The defense counsel at trial did request the Padova instruction that was given consistent with the Toolan opinion and consistent with the defendant's request. And there is no support in the law, and there is no support in anywhere in Massachusetts for Judge Nickerson to go beyond that and instruct now that whether addiction rendered the defendant incapable of resisting the urge to use substances. And it's the Commonwealth's position, as I argued in my brief, that this is an issue that wasn't fully vetted at trial. There was no motion asking for this instruction about addiction. There was nothing on the record asking about this instruction. The judge provided the defendant what he requested and what this court suggested in the Toolan opinion. And I suggest that the record is not fully developed to address this issue. This is a direct appeal. There was no motion for a new trial. There was no motion filed in the lower court for these instructions. And there's not enough on the record to expand beyond the Sheehan decision. And for those reasons, I suggest that the judge properly instructed with the Padova instruction. Lastly, I'd ask that this court decline to exercise its discretion to reduce the verdict under 33E. This crime was one based on the victim's decision to leave a relationship that was not healthy, and she was stabbed over 20 times for that decision. The defendant went from New York to Nantucket, entered her home, bought a knife that morning, and stabbed her. And for that reason, the facts of this case warrant nothing less than a first-degree murder. The jury heard from the experts on criminal responsibility and diminished capacity and rejected that. That's a question for the jury. And if there are no further questions, I rest on my brief.